Right, I think we are recording. So good morning, good morning, good morning to everyone, and welcome back to our continual series in legal education in the real estate sphere. So very grateful today to be joined today by Lia of Weir Folds. Lia was, as we will discuss, successful in a recent case. But before I get to that, I'd like to just give the normal caveats that we always give, and you guys probably can recite them now yourself in your sleep. Firstly, though our forum is private, these videos are public, meaning that anything that you say, any questions you ask will be going out on a variety of public fora, so please be advised about that. Secondly, we're hitting the spring months, and I just wanted to let people know that we've taken a bit of a break in having these video sessions, and that's partially because Greg and I have been running the teaching sessions, and there's been a lot of video sessions taking place in the background. But we do intend to ramp these up as the spring and the summer hit. Good time for learning, and we'll be releasing a whole series of upcoming videos on a variety of subjects that affect our group as we move forward. So I'm happy about that. Last, please tell your friends, invite them to our group. We believe that the more there are, the stronger we are collectively, and we are able to learn from one another and benefit from one another. So please do ask your friends to join. We are, I think, across our groups now at something like 20,000 strong, and that's a credit to the quality and the efforts that every single one of us put into these groups, and we're very grateful for that. All right, without further ado, let's turn to the star of the hour. Lia, thank you. Lia is from Weir Folds, and she's joining us on the heels of a victory that so many of us have dreamt of seeing in the courts. And that's not to say that there haven't been previous victories to this effect. I know our own Greg Whedon has previously spoken about certain applications that have been brought to the court to challenge builder statement of adjustments. But quite frankly, these judgments are far few and in between. The the agreements of purchase and sale that are signed with builders are seen as somewhat airtight and certainly are very difficult to challenge. And Lia has successfully done so and really set a bar for what is reasonable and what is not. Reading through her decision, which is something I've posted on our forum several times at this point, has been instructive and illustrative in how lawyers should be dealing with builders that are loading on erroneous charges. And I figured that rather than me blabbing on about it, we'd get right to the source. It's now 10:05. Lia, so grateful for you, so grateful for your firm's work in this regard. If you can introduce yourself, please tell us a bit about your judgment. Tell us a bit about the general concept of, I guess, what is good faith or using the contract for its stated ends. We're just very anxious and grateful for your presence here today as you kind of take us through this.
Yes. Okay. Well, thanks, Mark. Thanks for having me. I'm happy to be here to talk about this. So, as Mark said, I'll introduce myself and then I'll share my screen in a little bit. But my name's Lia Boritz. I'm a partner in the commercial litigation group at Weir Folds. I have a general practice, but a lot of it focuses on real property, which is real estate disputes, but also, like, for example, failed real estate transactions, but also property rights, easements, nuisance, those kinds of things as well. This particular case, sharing my screen, great.
We got it.
Great. So this particular case I'm here to discuss is that a few years ago, we were approached by a group of purchasers of a townhouse complex who had mere days before closing were given these statements of adjustments that were pretty exorbitant and out of proportion to what everyone expected. And there was a suspicion based on the documents that the purchasers had seen at that point that some of the charges were not proper based on the contract. And so I'm going to talk to you about that. I'm going to talk to you about the case, I'm going to show you what the contract said or what the relevant contract provision said and what the court said about them, as well as what the developer tried to argue in support in defending their contract. and their actions. So like I said, purchasers of pre-construction units of a townhouse complex, they challenged these last-minute closing adjustments. So a few days before closing, they were given statements of adjustments which sought to impose adjustments related to utility meter installation charges, which ranged from $44,000 to $86,000. And to give you some context, most of these condo units ranged between $400,000 and $700,000 purchase price. And so in some instances, you had adjustments that were a 20% increase in the purchase price of these units. So you could understand why these purchasers were so taken aback by the size of the charges and wanted to do something about it. Just so you're aware, on top of the utility meter charges that were imposed in these statements of adjustments, there were also charges imposed for parkland levies and development charges. But in this case, most of our clients had negotiated caps on the development charge fees, and so that we didn't really challenge those. And in terms of the parkland levies, we initially challenged the parkland levies, but then were given enough information through the litigation process that we dropped that challenge. And so all we were really focused on for this case were the adjustments imposed for the utility meter installation. But with those additional adjustments, some of the purchasers were faced with closing adjustment charges of over $100,000. So this was a pretty big deal for them. What I understand in this complex is that there's some purchasers who could not close, and they were represented by other lawyers, and I don't really know what happened to them. With this case of everyone we represented, they all closed under protest. So they noted their objection to the adjustments, but they closed under protest to avoid losing their deposits or risking litigation against them for failure to close. And then on the day of closing, we commenced this application to the court. The core legal topics that the court considered was, one, whether the adjustments imposed or the adjustment clause in the agreement of purchase and sale allowed the charges imposed by the developer, whether the developer could rely on what they called a vendor's certificate, and we'll talk about that more later, and whether the limitation of liability clause in the agreement of purchase and sale was applicable. So it's a little small. This is the actual contractual language in the agreement of purchase and sale. So and there's a few other applicable clauses, but for the purposes of what the developer was permitted to charge, it would very specifically said a reimbursement. And so it's going to get a little technical here, and I apologize for that if it gets a little bit, but in terms of this application, it really was a contractual interpretation exercise, at least from our perspective. And so we did have to get into the technicalities of this language in order to prove our point, which is that the developer breached the actual language of the agreements of purchase and sale, but also acted in bad faith in the way they communicated what the agreement of purchase and sale let them do. And this is, again, in the context of a Tarion protected agreement or a Tarion backed agreement, where there's additional consumer protections that are around. And so that's just the context we're in. So it gets a little bit technical, but the clause specifically said that they're entitled to a reimbursement, which one is, to us at least, said that they had to have actually paid it. So one thing is, if you're reimbursing someone, they needed to incur the charge. And so here we have A, which is the cost of water, meter cost, installation and connection charges, hydro and gas meter installation and connection charges. So that was A, they were allowed to charge that. And then B, they were allowed to charge a proportionate share of electricity, gas, water, sanitary, drain, and sewer infrastructure, installation, connection, and energization cost, and very importantly, paid by the vendor to or deposited by the vendor with the municipality or utility service provider. And so that bolded and underlined part of this clause is what was consistently in our argument ignored by the developer in this case. So they took the first part of it and this idea that they could charge a proportionate share of all of these infrastructure charges, but they consistently ignored this paid by the vendor to or deposited by the vendor with the municipality or utility service provider. And then under that, we see that the purchaser acknowledged that a certificate from the vendor confirming the costs would be sufficient evidence for the purpose of calculating this adjustment item. So we're going to talk about all of these statements, but those are the contractual clauses that were of most importance here when we're talking about what the developer was permitted to charge. So in terms of what the developer was permitted to charge, the court found that it was the APS only permitted reimbursement for, and A was the meter installation costs for individual units, so that was the A, and B was a proportionate share of these various infrastructure installation and connection charges, but they had to have been paid by the developer to the municipality or utility service providers. So that held. So what the contract says is what the contract meant, basically. And the court's reasoning behind all of this was based on the plain and ordinary meaning of the words, that paid by the vendor to or deposited with the municipality or utility service provider, that was a limitation to what the developer was permitted to charge pursuant to the agreement of purchase and sale. And so in doing so, the developer tried to argue that utility service providers could mean so many different things. It's not just gas or hydro. It could mean the contractors or the third party, any third parties they paid to install those utility services pursuant to, plans that the utility service providers gave them. It wasn't just Enbridge or Electra or whatever the utility service provider is, which is what anyone on the street would think of when they're thinking about utility service provider. It could mean their own internal costs. And the court just flatly rejected this. First, based on the plain and ordinary meaning of the words, it was clear that utility service provider meant utility service provider, but the developer's own information and in the evidence that they presented throughout this application, their own documents described utility service providers as Enbridge or Electra or what you would think of in that situation. So the court did not have a lot of time for that argument. And so again, based on the plain and ordinary meaning of the contract terms, the developer wasn't entitled to try to recover internal construction costs. And what the court found was that based on the evidence of the developers, that really this project just became a bit more expensive than they anticipated, partially due to its proximity. It was really close to a GO rail line. And so there was parts of this construction that was more costly than they anticipated, but they, instead of eating those costs or saying that was a mistake on our part, it appeared that they were trying to put those charges onto the consumers or onto the purchasers in order to help their bottom line. And that was a pretty big non-starter for the judge, particularly when we're talking about contracts that are backed in this Tarion environment where there's a big importance of consumer protection. It's not just individuals, one builder and one homeowner here, where there may be even a more less of a bargaining imbalance. Here there's standard form contracts for the most part given to every purchaser of this complex, and the developer in this case had to be more clear and more transparent if that's what they intended to do. So what the court said was, if that's what you wanted to do, if you wanted to be able to recover internal development costs that went beyond what you anticipated, you had to say so. And because you didn't, we're not going to let you do it. This idea of the court didn't actually have found that there was no ambiguity to these contractual provisions, but they said that even if there was ambiguity, they would apply contra preferentum, which is a Latin term just to say that it's going to be interpreted against the party that drafted the agreement. So even if there was ambiguity, which there wasn't in this case, it would have been applied in favor of the purchasers. On top of that, the court found that the developer's interpretation was just commercially unreasonable. So if the court went along with the developer's interpretation, this would expose consumers to unpredictable, significant development costs that should have been included in the purchase price, but weren't because of the developer's own failures to properly estimate what their costs were. And so and which costs should have been included in the purchase price originally. So the significance, and part of it's the significance of the amount of these adjustments in proportion to the purchase price, either just underscored how unreasonable the developer's interpretation of this agreement was. And it's like, so, and the court found that this could, if the developer was permitted to do this, then it would let other developers just go back and use these clauses in either to rein back in or to bolster their bottom line, so they're not losing money on a project that they just didn't estimate properly. And also it could even allow purchasers to raise costs developers to impose costs in the hopes that purchasers maybe couldn't close. So then they can then go ahead and resell these properties to other purchasers for a higher price. So the court just was not willing to go with the developer's reasoning here. In terms of the vendor certificate, so as I showed you in one of the previous slides, what the APS said is that the purchaser acknowledged that a vendor certificate was sufficient evidence for the purpose of calculating the adjustment item. And so the court had a few things to say about this. The developer argued that it was entitled to rely on the vendor certificate as sufficient evidence of the charges permitted under the APS, which meant that one, it did not require it wasn't required to provide the purchasers with any backup documentation to prove the charges, and also that the court wasn't even entitled to look behind their certificate to determine whether or not these charges were proper. And I mean, I think you could understand the court said, no, you cannot insulate yourselves from challenge for a few different reasons. So the court rejected this idea that it was not permitted to look behind the vendor certificate, and it said so for a few reasons. One is that the language of the APS didn't say that it was a conclusive, final, and binding statement that could not be challenged. So that was not written anywhere. The court also looked to the plain and ordinary meaning of this clause, i.e. evidence, and the court said, well, evidence in court can be rebutted. Evidence is something that the court looks at to determine whether or not someone has breached or has not breached a contract. So just calling it sufficient evidence was not enough to make it something that couldn't be challenged. But again, here, the developer's interpretation was deemed to be commercially unreasonable. The court said that if the developer was correct, that means that, and the certificates were the last word and could never be challenged in the courts, it means that the developer, if you followed through with their interpretation, they could charge millions of dollars. They could have certificates that had any costs in there, and then the purchasers would either be obliged to pay them or be in breach. And that's just not, especially in the context of a standard form contract or in a space where consumer protections are important. The court said that just couldn't be a reasonable interpretation of what this clause was trying to say. So they could do this, again, like I said, the purchasers, they could do this in situations where they've sold a unit and the market, let's say, increases. So maybe condos are worth more than they were when they originally entered into these agreements of purchase and sale. And again, they could get out of agreements or try to get out of agreements by having purchasers fail to close and then resell for a higher amount. So the court was not prepared to go with the developer's interpretation. Here, the judge said if there was ambiguity into whether sufficient evidence meant that it was conclusive, that she would have interpreted this clause in favor of the purchasers. And then more importantly, the developer's own evidence is the thing that called the certificate into question. And so just to give you some context on that, once these statements of adjustments were handed out to these purchasers, as you can expect, their lawyers who are working on these transactions all started saying, hold up, what is going on here? What are all of these charges? And I think that there was enough noise back to the developer that a couple days after these adjustments were handed out, they sent an email to the purchasers that gave what they called backup documentation to the charges. And what this backup documentation showed was, I mean, it wasn't very detailed, but it did show that there was amounts paid to contractors, to for management fees. It gave the purchasers basically the evidence to say, these aren't charges to the municipality. These aren't charges to utility service providers. These are charges to your own engineers, to your own contractors. These are internal development costs. And it was that evidence, which the court said, that's used to say, you're admitting basically that you've breached the agreement by the own evidence that you provided to the purchasers. So on top of the fact that they didn't agree that the clause meant that the court couldn't review it anyways, it was that the developer provided the evidence that called the certificate and the veracity of the certificate into question. So the court was not prepared to permit the developer to rely on it. And there was in addition to that, there was other evidence of bad faith. So the developer, in explaining what these costs were, had shifting explanations. So at first, the original statement of adjustment provided said that the charges were for the proportionate charges. So again, this is the under B, although it was unclear really if it was for the A and B, so the utility meters charges and the proportionate charges. But the statement of adjustment said that it was for utility meter installation charges, when that was not accurate. When questions were asked, the developer provided the certificate, but then added that the adjustments were for the installation and connection charges and a proportionate share of these infrastructure charges without specifying who these amounts were paid to. And then the developer also sent an email to the purchasers with a letter which claimed it was entitled to charge the purchasers more than what it was permitted under the APS. So they wrote this letter saying, you entered into these agreements where you agreed that all costs associated with the engineering, installation, and connection of utility services would be paid. So they were explaining to the purchasers what they said they were permitted to charge, but it was an incorrect interpretation. It was their very broad interpretation rather than what the clause actually said. And so what the court found was that the developer consistently ignored the requirements of the APS while representing to the purchasers they were all the amounts that they charged were lawful. And the court found that in doing that, the developer did not act honestly, impartially, or in good faith. And as a result, on top of the fact that they found that based on the plain and ordinary meaning of the words, that the purchasers were permitted to challenge the certificate in court, they said, but also the bad faith actions of the developer was, again, a further reason why they could not rely on this certificate. And so both of those permitted the purchasers to to challenge these charges in court. And based on the admissions of the developer, both through their own evidence and also through our cross-examinations, et cetera, the developer essentially had admitted that they had passed on charges which they were not permitted to under the APS. So then the developer tried to, and I know there's a lot of writing, don't worry about it. It's just, I wanted to show you what these clauses say, but the developer said, okay, fine. So even if we did default or breach this agreement, there is a limitation of liability clause, which says that the purchasers aren't entitled to any damages. Like they don't have any remedy here. And so on the left side of the screen, you can see that this is the limitation of liability clause in the APS. But as is clear, it said it was subject always to the Tarion addendum, which was the Tarion addendum to the APS. But what the limitation of liability clause tried to do was insulate the developer from any default under the agreement. And so, the Tarion addendum, there was there's a few more sections that were relevant, but for the most part, we had Section 8 of the Tarion addendum, which said that only the items set out in Schedule B could be the subject of an adjustment. And Schedule B, part of that listed the same clause that we looked at already. It was the same clause that was in the APS, which talked about the proportionate share paid by the vendor to the municipality or a utility service provider. It just mirrored that language. But also that in the APS, it said that any provision of the developer's purchase agreement, which conflicts with or was inconsistent with the addendum, that the addendum would prevail, basically. And so what the court said was the limitation of liability clause isn't applicable in this case, and that was for a few reasons. First, just based on ordinary principles of interpretation, applying this exclusion clause would be inconsistent with the Tarion addendum, and that's based on what I kind of just took you through, that if the Tarion addendum only permits them to charge what's permitted in Schedule B, which is charges that are paid by the vendor, by the developer, to the municipality or to a utility service provider, then it would be inconsistent to then let them rely on a limitation of liability clause, which would get them out of charging amounts that were not specifically set out in the Schedule B. So, like just looking at how all of these clauses interplay with each other. And again, what it would do was, if the developer was right here, then it would shield the developer for blatantly charging significant amounts that it was not entitled to. And because of that, the court also found that it would be unconscionable. It would be unconscionable to let a developer rely on such a clause because it wasn't permitted to do so at the outset. So from the outset, that clause was unconscionable. And then also, just given the space that we were in, the court found that there was an overriding public policy interest in preventing developers from escaping liability when they've secretly or not transparently or in bad faith tried to charge purchasers for amounts which they are clearly not entitled to under the terms of the APS. And so there was a strong public interest which outweighed the enforcement or the strict enforcement of the limitation of liability clause that was in that contract. And so at the end of the day, what happened was the court granted various declarations which related to its interpretation of the APS, and I've taken you through some of those. And then it ordered a reference on damages, because in theory, we didn't get a lot of information. Throughout this litigation, we didn't get a lot of information because the developer was really stuck to this idea that it was not required or it wasn't necessary for them to provide the purchasers or the court with any backup documentation. And so we weren't able to get up to this point in the litigation, to the application hearing, was any detailed information about what charges were actually paid that they were permitted to charge. So we weren't taking the position that none of these adjustments were permitted, because the purchasers did agree that, their utility meter installation charges would be permitted and they could have some proportionate share of those amounts paid to the city. But what we didn't get through this process was any detailed information about those specific amounts. And so we were sent, and this process will happen eventually, for a reference on damages, so we can get that information and the court will determine what the developer was actually permitted versus not permitted, and then the purchasers can get reimbursed for those amounts, or hopefully reimbursed for those amounts that were not permitted given the court's interpretation. And so just some key takeaways for lawyers, for real estate professionals, when you're faced with these kind of clauses. Look at the adjustment clause, because for us, and I've seen different adjustment clauses, some of them are much more broad even than the one in this, in saying that they can charge internal development costs. They can charge for any costs that are over and beyond what they estimated. There are ways to word these statements to be much more broad, but before you have, if you are giving advice to a purchaser before they enter into these agreements, to look at these adjustment clauses to ensure that you understand what's permitted, because depending on the way that these clauses are drafted, there may be no recourse, or there may be no reasonable recourse to when you're challenging them in court. For us, like I said at the beginning, this really was a contractual interpretation exercise where it wasn't just the bad faith of it all, or it wasn't just the fact that the adjustments were huge. It was the fact that they weren't permitted under the APS. And I think that it was the contractual interpretation that went further than the bad faith part. The bad faith was a bad fact for the developer, and I think helped us a lot. But if the developer had really just been going along with what the APS said it could do, we wouldn't have had the same type of case. If you're faced with these big adjustments and they're unexplained, then I would seek backup documentation before you close. What this case tells us is that certificates are not immune from scrutiny. And in this case, it was also important that the certificate was the vendor themselves that were issuing the certificate. There are cases especially in construction and development cases, where a certificate for some charges will be issued by a third party, like an architect or an engineer, or someone who also has professional obligations that go along with it. And a court would likely look to those with a bit more deference than they do to a vendor who's putting together their own certificate, because there's much more of a reason for that vendor to act in their own self-interest than it is for, even if the engineer's hired by the developer, they still have their own professional obligations to be accurate. And so certificates are generally not immune from scrutiny, but it will obviously depend on the facts of the case. And consumer protection matters. Tarion addendum in this case had real teeth, and the courts were willing to support consumers where the charges were unjustified, but also where the Tarion addendum made it clear that that's what they were supposed to do. And then for developers, and I don't know if there's anybody who acts for developers or is a developer in this forum, but be careful about the way you draft your agreements of purchase and sale. Make them clear, make them transparent. Don't try to foist these hidden charges at closing, because that might not be tolerated if you're not permitted to do so under the APS. Avoid inconsistent documentation. Here, for example, the developer got caught because the communications they were sending to purchasers were not consistent. They had different and changing explanations for the costs that they were delivering. And here, the cost of bad faith was high. So misleading, aggressive practices, they can lead not to just repayment, but reputational harm, legal costs, and who knows, regulatory scrutiny maybe, depending on if someone reports them or if you open up an investigation with the regulatory agencies. But that's the case, and that's what we did. And so we were, in our view, very successful here, and we still have a little bit to go to get the full force of the remedies. We still have our reference to do, but at least for the first step, we got the interpretations we wanted, which will lead to inevitably, it's clear the developer, there were improper charges there. So we should be able to get some money, hopefully back to the purchasers, depending on if the developer has any money left to give us. So that's it. So any questions?
I don't usually do this, but I'm going to take umbrage. I'm going to actually take advantage of being one of the co-hosts here and ask the first question. Really, really interesting stuff. First off, before I say anything else, bravo and thank you on behalf of the conveyance bar. We've needed interpretation guidelines like this for some time. I'll tell you that one of the ways that, and one of the reasons I was very excited about this, if I'm to be very blunt, Leah, is because this goes well beyond statement of adjustments. One of the areas that we're seeing increasing bad faith, particularly for builders, is where they are trying to extend periods under the unavoidable delay, specifically because financing is becoming such an issue for them. So they're pushing out their construction periods. We've seen, I'm not kidding about this, migratory bird patterns be a reason for delay. We last week had COVID delay sent to us last week in 2025, stating that there was a delay for COVID. And we're decisively figuring out that people aren't using things in good faith in a variety of other respects that go well beyond the statement of adjustments, and everything that you've talked about, the contract referendum and all the other points are directly applicable to a builder acting in bad faith. My question is this. You have a very remarkable skill set that we're all very grateful for. You have the ability to litigate. Most of the people who are on this channel are conveyance lawyers and do daily conveyance. The problem we have is in having this information released, which you can get through the litigation process, through examinations for discovery and the like, but we do not have that availability. What does a lawyer in our position, feeling that a builder is dealing in bad faith, do in these instances, given that most people do not have the ability to litigate, and litigation often involves not closing if it is more significant enough, bringing on a host of other liabilities to the purchaser and forcing litigation down people's throat? What do we do practically, and how do we give efficacy to what it is you have now proven through the courts?
Well, okay, so there's a few things, and one, it's a lot of it's going to depend, I think, on the situation. So one of the reasons we were able to litigate in this situation is because we had a group of people who, because of that, the litigation costs were dispersed, right? And so I think that when we're dealing one-on-one, it's really hard because you have someone who's already either wants this property or has to come up with all of these last minute this funding, and then you're saying, oh, but you should also litigate to get some of this money back. And that's not necessarily something that people are able to do if you don't have a group of people who are willing to get together, like we had in this case. And so I do know that in this particular context, there were people who did not close, and they did have to commence some litigation, but they didn't do it with us. They weren't able to close, and they knew that they would get potentially some litigation from the developer for failure to close, but they did an anticipatory claim and then they settled. And so I don't know if I don't know what the terms of the settlement was, but the developer did do a quick settlement with these people who were not part of the bigger litigation, and maybe it was a benefit to them that they weren't in that case, but and they gave them some money. I don't know how much, I don't know to what extent, but they let them exit their agreement of purchase and sale and get their deposit back, and I think that was it. So they were able to exit that way, but they did have to commence this anticipatory litigation to do so. And I don't know if that would be successful in other areas of this. But I think that what it does, it's like, I don't know to what extent a lot of people go and seek out legal advice before they're entering into these standard form contracts. You know, like when people buy their houses, they enter into an agreement of purchase and sale before they ever speak to their lawyer. And so I think that a lot of it comes with education. And then when you're faced with these agreements, I would do your best to demand to the extent you can, whatever information you can. I know you're never in a great position, but demand what you can. And if the client you're acting for can't close, you might have to consider litigation. Like we're not in a situation where the bargaining power between a developer and an individual purchaser, it's quite outbalanced. And so sometimes it might take commencing that litigation to force the developer into either providing the information or giving someone a deal or letting them settle or back out.
I'm going to follow up, if you don't mind, with one quick follow-up question, and then I'm going to open it up. I'm sorry, I'm monopolizing a bit here. I apologize. What was the reason that you chose the litigation strategy you chose? I have seen other people deploy a 3-1 vendor purchaser application. 3-1 stipulates that you are allowed to challenge any part of a contract with a builder. Technically, it really shouldn't include statement of adjustments charges, but I've seen courts do that in the past. Why did you choose to go by way of statement of claim as opposed to an application? Was it because the closing had already finished at that point? What was your thought process behind the way you selected your litigation?
So we actually started an application also. So we didn't do this by way of statement of claim. This was an application.
All right.
And we started by way of application because we wanted to get a fast injunction. We were trying to get an injunction to make the builder hold on to some of the closing costs to make the litigation, to know that we would have money at the end of the day. And
Yep.
so we did it quite quickly, and we wanted to do it by way of application. We didn't end up getting that injunction, unfortunately, for various reasons, but that was our thinking behind it. And we also wanted to try to keep the litigation process as streamlined and as quick as possible, especially given our view was that this was a contractual interpretation issue. And we were concerned that if we went by way of action, that it would end up being much more expensive for our clients to have to go through affidavits of documents, examinations for discovery, rather than keep it focused on this contractual interpretation issue, which we felt to be quite straightforward. And so that's why we chose an application, because we thought it was very narrow. At the same time, we ran into some issues going by way of application, because the discovery rights are more limited than by way of action. So in an action, in examinations for discovery, the developer might have been required to release more information than they did in the application through the obligations they have in an affidavit of documents. But in my perspective, in this case, given the positions the developer was taking, is that I think they would have refused to give us the documents no matter what, and said they weren't relevant. So I don't know if at the end of the day we would have been in a different place or gotten any more documents than we did going by way of application. But the primary reason we chose application is because we felt it would be faster and less costly to our clients by still getting this contractual interpretation issue.
Understood. I'm going to read Camille's question to you, if you don't mind, in the chat. She asks, would you say that the holes in this particular developer's contract are typical, or are they unique to this law firm's APS drafting?
I think that it's typical. Like, I haven't seen a million of these pre-construction contracts. I've seen a few, and I've seen some that are drafted more broadly and give the developer more rights of adjustment than this one. I think in this one I think this was probably a more standard form contract, and those exclusions was more standard form, and maybe something the developer didn't even clue themselves into so much, because I think that this limitation that they were only entitled to be reimbursed for costs paid to the municipality or utility service providers really wasn't what they intended. I think that maybe that's giving too much credit to the developer. I don't know. Is that I think that they didn't. That was actually what they intended, and then when everything got more expensive, they tried to use this clause to their benefit, even though it was not the right interpretation. But so I don't know. So I do think it's unique to each contract. Each contractual interpretation Each contract is going to have its own interpretation. And so you have to look for the holes in any different contract that you find.
Perfect. If anyone else has a question, now's the time to unmute yourself and feel free, please.
Sandra Jackson here. I'm actually a real estate agent, so this is going to be aimed at the realtors in the group. I read case law as a hobby, and I read this case, and congratulations. I feel it's very, very important. I used to be involved in land development in Mississauga years ago. I was surprised that you got so much accomplished in just one day hearing. I would have expected this to go over like 3 days, but this was a complicated case. You put a lot of evidence in and argued it successfully that it was 1 day. So I was very surprised on that. As a realtor, do you feel that Tarion and bad faith cover us enough? Or do you think that because of this decision, because I feel it is important to the builder industry, do you think they're going to tighten up their language?
I think they're going to tighten up their language, 100%. I think that's why this case is good, and it shows you that Tarion can be used to back up consumers. But I think that it also will show developers how to tighten what they need to do to make sure that their agreement of purchase and sale lets them charge for whatever they want them to charge the purchasers for. And that's why I think it's for all of, especially real estate professionals, the realtors, who are the ones who have like kind of a first line of they're the first line here, and they're the ones who see the agreements more often before the purchaser sign them, is to take a look at those adjustment clauses and really look at them so you can give the advice to the purchasers when they're entering into these agreements, if you're involved in those transactions, because I do think that it just will cause developers to draft around it and make their language more precise.
That's what I feel. This is why they need to have a lawyer review it if they can.
Yeah.
Great. Thank you. Again, congratulations on this one. I enjoyed reading it.
Thanks.
Sanchita, you're up next. Sanchita's a lawyer with our group.
Thanks, Mark. Hi, Leah. Thank you so much. This
Hi.
was so great. And like Mark said, I think this was much needed, just because sometimes as conveyance lawyers, we struggle to really get the disclosure that you were able to get from the builder and their lawyers, especially when we are sort of smaller firms and we're dealing with bigger firms. It can be a little bit intimidating trying to request this information. But having said that, my question is related to assignments. So how would we deal with this in an assignment instance where we're representing the assignee? The agreement was already signed and done several years ago, right? And let's say as assignee's lawyer, we review the agreement and we find all these additional costs. At that point, do we have any recourse, or do we just wait till after closing and then, refer them to a litigator who can potentially dispute these charges? Or what would you suggest how we proceed with that?
Well, I think that the difference, so if you're getting assigned the contract, you're still expecting the developer to abide by the terms of the contract. And so, yes, on one hand, you're accepting the terms for what they are. But even in this case, if I accepted the terms for what they are, it still tells me, again, in their specific case, the developer was only permitted to charge certain charges. So just because you're getting assigned the contract doesn't mean that you're accepting that the developer can charge whatever they want. You're expecting that the developer would charge only what they're permitted to under the APS. And so I don't think that at the time of assignment, I don't know if there's much you can do. You can negotiate maybe with the assignee, your assignor, but I don't think that that's really the point at which there's much to do. I think it's going to be, again, if the developer or the vendor breaches the contract, the assignee should still have the same rights because they expected the developer to abide by the terms of the contract.
Makes sense. Thank you.
Mill, you're up. Camille, feel free to unmute yourself.
Yeah, sorry about that. Yeah, so I may have missed the part of the presentation where you may have mentioned this, but I saw a lot of mention about just sewer connection charges, utility charges. Are you able to say if any of the 100,000 charges that were charged over were development charge related, or any of the other charges, parks levies charges?
So yeah, so I did say, so you might have missed at the beginning. So
Yeah.
there were charges, part of the adjustments that were charged were related to development charges and parkland levies. But in this case, most of the purchasers had negotiated caps on the development charges, so it wasn't something we could really challenge. And also with parkland levies, we did initially challenge them, but we were able to get sufficient documentation to prove that what they were charged, that it was all kind of kosher. And so we didn't end up so our initial application did challenge those fees, but we dropped those challenges throughout.
Okay, all right, thanks.
All right, guys, let's open it up for one last question, and then I will extend our gracious thanks. Who wants to be the last brave soul? Leah's proving very nice, guys. No problems here. You can do it. I'll keep it open for 5 more seconds here.
I see someone in the comments ask, what is anticipatory litigation?
Okay, anticipatory litigation. So in this case, what you can anticipate is that as a purchaser, if you fail to close, you might anticipate that the developer would bring a claim against you for failure to close, and for damages, let's say if they couldn't sell the condo or the unit for the same price that you purchased it for, so they would want to claim the difference. And an anticipatory litigation would be that instead the purchaser might bring a claim against the developer or the vendor to one, maybe challenge the adjustments, but also try to get out of the purchase and then get their deposit back without actually closing. And so it's kind of, you're the first one. There might be litigation that could come from both sides, and you're anticipating that the developer would bring something against you, but you do it first. Kind of gives you a little bit of an upper hand rather than being the defendant in the action. You're the plaintiff.
All right. Leah, I think I'm gonna wrap up here, and I'm going to extend a sincere thanks. I have said on this channel before that there is a world of difference. The fact that someone calls themselves a litigator does not mean that they are a litigator that can achieve what it is you've achieved. Similarly, conveyance lawyers, when you run into trouble, there is a significant difference in realtors. We aren't doing commoditized product work. We're doing work that is particular, and showing and being able to display your chops as you have here today, as you have in your career. Obviously, you're with a prestigious firm. You've made partner there. From our perspective, we are incredibly grateful for your expertise, for what you bring to the table, and for sharing that expertise with us, making us collectively better as a group. It means a lot. We do get a lot. We have quite a few people actually that are on our forum, many of whom have these types of issues. You will become a trusted name for us. You obviously have the expertise and the resources to assist. And I, for one, but on behalf of our entire group, are incredibly grateful for your time, for your energies, and above all, for your contribution to the body of law, which is going to make our practice easier, better, and more refined, such that we know what we need to do when our clients encounter such problems. So thank you, thank you, thank you. Everyone, Leah, do you want to just mention your contact details just before you go, and or put them up on the screen, or anything else, just so people know how to contact you? Leah's with Weir Folds, guys, easily accessible.
Yes, I will put them back up on the screen quickly.
That'd be good. That would be great. And guys, it's not hard to look her up. There's this thing called Google. It's really effective these days. Simple, straightforward.
So you'll see here, my contact information is here, but yes, you can just Google Lia Boritz, Weir Folds, Lia Boritz lawyer, and I'll show up there also. And happy to connect with any of you.
Guys, and if you could give back in turn, if any of you have a collection of people who are having problems with the builder, assemble them, bring them over to Leah. Leah clearly has the expertise to handle these things, and she will be on my to-go list as well, going forward. So, Lia, thank you again. Sincerely appreciate your time. And everyone, thank you for being here. This will be publicly posted shortly. And of course, that's where the vast majority of our views come in. Lia, I'll give you a link to that in short order as well.
Thank you so much. Thanks, everyone.
Our best.